Welcome to Childhood and Youth Studies 2212, Childhood in the Law. I'm recording this for you uh, earlier in the week from Barbados. As the TAs, I think, have probably told you, I have been delayed there, unable to fly back due to the United States seizure of the president of Venezuela. It created a no-fly zone around Barbados during the time we were supposed to return. So that has delayed us for a week. But as you can see from some of the photographs, I'm doing just fine. There are worse places to be trapped for a week, but I do wish that I was able to be with you for this first class. Fortunately, you're in good hands. Xander and Madison are there, and after I say a little bit about myself, maybe they can stop the video and say a little bit about themselves. So I'm the chair of the department, and I wrote the book that was is used for this class. I'm a historian of social policy and law and discourses of childhood and youth. Uh, I designed this course years ago with some unique features. As will become clear in the presentation today, the introduction to the course, you'll be briefing cases and mooting cases, and we're going to use what's called leading cases. Sometimes they're called landmark cases in Canadian law to explore some really foundational issues that people in social services and programs and advocates for children and teachers all will come across in their careers, and it's important that they're competent in their understanding of the issues that we'll confront. It's also going to be an opportunity to reflect on deep issues about the relationships between the generations, the relationships between the family and the state, and we're going to be very active in this court. You're going in this, excuse me, in this class because you're going to be participating in a moot court where you'll do role play. You'll learn to write legal briefs to help you sort of be able to capture the essence of a legal decision and why it's important for the present. You're going to have an opportunity to expand your vocabulary and in ways that will enrich your understanding of childhood and youth. So that's a little bit about myself, and now Xander and Madison can say a little bit about themselves. I guess I'd like to start uh, by just reviewing the formal description of the course and to get into a little bit more detail. Uh, During through these cases, through mooting cases and briefing cases and understanding the situation of a case, we're going to deal with um, key concepts and principles like the best interest of the child. We're going to explore custody and access law, or family law. Also, child support will be dealt with. We're going to deal with a constitutional challenge to uh, parental right to use corporal punishment on children. We're going to deal with a case that explores the boundaries for the duty to report. We're going to examine children's evidence and the laws that protect them from sexual abuse, and then finish up with a case that deals with the role, or that shows the role, of liability law in remedying the harm suffered by children in care, especially through the Indian residential school scandal and the litigation and its consequences for Canada. There are probably about 100 between 100 and 120 new words that you're going to learn meanings of through this course. That's really a central aspect of it, and I'll get to showing you where those words are located and some of the methods we're going to use to expand your vocabulary in a moment. Maybe I'll switch screens as we're recording here and just go straight to the place where the information for the courses is located. So this is a view of the Brightspace page for this course. If we go to the course home. So this is what you'll notice is if you go to to our Brightspace, which I've sent you an email that uh, links you to this page. Many of you will just know to go to it as well. You'll see that I'm using Brightspace in a really elementary way. I know there's a lot of capacity that this tool has that I don't use, but I think I use it in a way that's good enough. What we have here is drop-down menus or boxes where you can link to pages which provide the course outline and the course schedule, course brief instructions, moot court instructions, and then these next three, DL 12, LH 105B, 105C, those are going to be the rooms where we're going to hold three different moot courts. You'll be assigned. The assignments aren't up yet. I'll make those assignments after I have a stronger sense of who's really in this class. People drop ad in the first week. You'll also find the test instructions for the first test on February 12th, the second test on March 5th, and the final exam are available. You'll see that you're going to be submitting assignments. There are six assignments or briefs that are due uh, during the term. Those are already scheduled, and you have instructions for those assignments in addition to the moot courts and to the exams. I'll just push on the course outline button and I provide here you'll see information where the moot courts are located, obviously where our class is, some information about CYS's program advisor, the names of the teaching assistants, and then my information where I have office hours. If you can come to my office, Wemple 255 on Thursdays after class, or you can schedule an appointment with me, reach out to me. One thing I would say about communicating with me is if you want to talk about a substantive issue, if you want to discuss ideas, or if it's a complicated matter, then we really do need to either have a Zoom call or an in-person meeting, and we can arrange that through email. But if you want to have a discussion, having it over email really doesn't work for me. And it's not that I don't want to help you, it's just that there are a lot more of you than there are of me. And so use the email for something really brief or to inform me that you have an issue or you need an excused absence, administrative stuff like that. Substantive stuff, you have to come talk to me or we'll set up a Zoom. So just be aware of those things. I have office hours and I'll make an appointment with you if that's what you need. Um, you'll see here sort of the standard things are available, and we'll go through these things, but read through this course outline to make sure you understand the basic policies of the course. Then I'll go down to the next button, course schedule. This is very important. And part of your job, in the first week is to get the book and to read through all of the instructions. I understand that when let's say you order something through Amazon and it comes and it says, well, before you set this up and begin, read all the instructions. And people really don't want to do that. But how many times has that caused a problem later? it will cause problems later. You need to read through the syllabus to understand the assignments and the rules and the scheduling so that you know what you're expected to do in each task, but also so that you can see, are there any conflicts? Do I need to communicate with the TAs or with the instructor because I can see a problem? If you do that well in advance, then we're going to try to make an accommodation for you. If it's after the fact, then it becomes difficult for us. So please read through all of these different instructions. And the first four here are really pretty important. Moot court instructions, case brief instructions, and the course schedule. So the course schedule, if I could just take that on, what this gives you is it gives you the reading assignment for the week. If we blow that up a little bit, you'll see that by January 15th, between now and January 15th, I'm asking you to get the book. It's required reading. A mistake that I think some students are making in this class is they're thinking, can I get through this without reading the book? Uh, the answer is just simply no. The book is tied into each case, all the key words, and I'm going to do what I can to make sure that the readings mesh right with the lectures, right with the exams. They're about what we're mooting, and they are the basis for writing the briefs. So there's no real space between what you're being asked to read and what you're being asked to do. And so if you don't do that reading, you're not going to be well prepared. So here is when you find out where you should read what you're supposed to read. Um, Also have the title of the lecture and a description of what we're doing in the tutorial. We're not going to moot a case until the 22nd of January. You can see that here. Next week, what we're going to do is we're going to have mooting practice to help you understand a moot. But we're also going to have a lecture next week where I'm going to provide formal definitions of some keywords: law, jurisdiction, legal doctrine, stare decisis. Sometimes these words are like the judgment holding, distinction, or fiduciary duty, or parents patri. Those words are sometimes defined within the book, and I will explain them further and directly in lecture. But there's an expectation that you're going to uh, for parents Petri, you're going to construct a notation based on what is said on page 3 and 17 through 22 that defines that term. That's part of the task of the course. You'll also see in the course calendar section um, that I'll have some links to some supplementary resources that I'll be showing you in the course of my lectures, or might be helpful uh, ancillary readings. The supplementary resources are not required. They're things that you might use because maybe you remember something from lecture and I showed it to you. You want to find it, you can click on it and go to it. Let me go back. So all of the instructions, as I've just shown you, are on Brightspace. And one of your main tasks this week, as I've said, is to go to the Brightspace page and read them, make yourself aware, and then bring any questions you have next week about the mechanics of the course or what's being expected of you. As I said earlier, here's a cover of the book, the required readings. It is essential for success in this course that you read the book. It's not just essential for academic success, although that's true. There's something important that happens when you read an academic work or when you read a novel, when you read something of substance, not just a tweet or something on social media, but something with a little more detail to it, you start to draw yourself and your mind into the story, into the issues. You are doing the work of creating the voice when you read. So by skipping or minimizing your reading and thinking it can be replaced, for example, by just listening to lectures, that's an error. That's to deny yourself part of the experience of learning, and I hope you won't do that. So here's uh, uh, a slide that summarizes what the course schedule contains, as I explained earlier. Here's some details about the marking system. There are really just three ways that you earn points in this class. We're going to moot 6 cases. When you participate in a moot, in a speaking role, and I'll get to these roles in a moment, when you're playing the role of the judge or playing the role of counsel for the parties in a dispute, you'll earn a percentage mark, like 0 to 100. And that average in all of the times you play those roles, that average will determine 18% of your mark. So you could break that down to 3% per moot. But you will also will be assigned at some point in the course more passive roles, but you're still required to be there. You could be assigned the role of the public. You could be assigned the role of the timekeeper. You could be assigned the role of the announcer. These roles are all explained in the instructions, and we'll have a chance to learn them in the first moots. In each of those cases, if you attend, you get an attendance mark. And what that really does is you are avoiding getting a 0. If you just decide to no-show without having received an excused absence when your public announcer timekeeper, that's a 0, and that will negatively impact your mark. So you're required to attend moot court, but you will earn your mark in moot court primarily when you are a justice or counsel. That's when you actually have to perform in a more robust way. So the moot courts are important for your mark, but they're also an experience that's going to attach you to the cases in a way that will assist you in remembering the case and doing well on the exam. Each time we have a moot court, you're also going to have to write a brief, and you'll submit that online. I have full instructions for the briefs that you can read about. That's just due by the end of the day whenever we moot a case. And then there are 3 tests that make up the lion's share of the marking systems. Uh, Collectively, those 3 tests uh, are worth 70% of the mark. There are instructions for those tests already available. So probably the most distinctive part of this course is the moot court and or the case method that we're using to learn about childhood and the law in Canada. So what is moot court? Well, moot court is a role play exercise which is similar to but distinct from mock trial. In moot court, we're going to be dealing with legal issues rather than questions of guilt or is innocence. So we're not going to be dealing in moot court directly with questions of who's guilty or what happened. Moot court is about cases on appeal or general answers to legal problems. So why do we do it? Well, it's a by role playing, you're going to have to be able to find your own voice and take all of the information from the book, from lectures, work with a group and come up with an argument that defends the side of the case that you've been assigned to. So by having to do that and role playing it, it increases the impact of your learning. So everything that we're doing in education is about that. It doesn't mean that it's always the most enjoyable thing from the point of view of the student. You might feel a little nervous, but that doesn't mean that it's not serving your educational interests. Um, so why are we mooting? Because it increases learning. So what are the roles? Well, let me go through and answer what are the roles in moot court, a little bit about the process and how we're going to evaluate your performance in moot court. And let me remind you that that we're not going to have to do this next week. We have a couple of weeks to get up to speed on these roles. Um, there are 5 roles as you see here in moot court. There's the counsel for whoever's appealing the decision that was below. There's a counsel that's going to be responding to the appeal. Those are the attorneys that are advocating for their clients. There will be the judges or the justices. So there will be 5 counsel students assigned as counsel on one side. There will be 5 students assigned as counsel on another side. And there will be 5 students assigned as justice in each moot court. We will have a student assigned to be the announcer. In many ways, the announcer works with their partner, the timekeeper, to keep us going through the steps of the moot, keep us on time. And the roles between announcer and timekeeper are just what they sound like. The timekeeper will be reading from a script at various stages. The timekeeper will make sure that that we go through those steps in a timely manner. And then there will be 2 or 3 or 4 students, depending on the week, who will be assigned the role of public. The public isn't just observers, they are observing the moot, and at the end of the moot, they're going to say to the group what their takeaway from this case from the week was. Um, I describe here what counsel for the parties do. They address the judges, and they have a time where they should probably take 3 of the 5 and assign them the opening statement, each taking one particular issue, dividing it up. So it's some teamwork beforehand, focusing on the legal issues, and telling the court, the justices, why they should rule in favor of their clients. And then there'll probably be 2 other um, counsel on that side. Their role will be to work together to prepare the rebuttal. So they'll be paying attention to what the other side says, to the questions the justice asked, and they'll have a time at the end where will speak to new issues that came up in the course of the court and provide some final points to support their side. Um, how do we judge what counsel does? How do we assess it? Well, we assess it by when we're observing you, we'll say, did you coordinate your roles? I provide some advice there. I strongly uh, advise you to take it. But you also will also be looking for some key things. Do you frame the facts of the case in a way to produce a legal question that you can use to benefit your clients? So frame the facts to produce a question that will benefit your clients. And then you have to explain to the justices why they should answer your question in a way that supports your client or their position on the case. In the course of doing those two key things, we want to see that you reference legal concepts, legislation, other cases to support your argument. It's really important that you interact with the book and the lectures, borrow reasoning from the court opinion or arguments to support your stance. It's not that you can't create something new, but show that you're engaged with the existing law. Also, respond to what was previously said in the moot. Um, Uh, you can, particularly if you're going second, the other side has presented something. There have been questions asked. Are you able to adjust what you're saying to respond to other points that have been made? Can you connect what you're saying in moot court to its impact in the future? What difference will the answer to this question make for children and youth or families, larger social and political relationships? We're also going to evaluate you based on how you present yourself. So the first areas, framing, explaining, referencing, borrowing, connecting, those are the substantive elements of your performance in moot court. But there are two things we really do not want you to do. Please do not just open a laptop, zero in on the screen, and read what you've written. That is not going to be very persuasive. Try to make eye contact with the panel of judges. Limit yourself to maybe one important point with two or three examples. You don't have very much time to begin with. So you should be able to say, Your Honors, the question before the court today is whether or not Eve's mother should be able to make a decision. This is from the first case. Eve's mother should be able to make a decision that will protect their family. Therefore, the court must be allowed to hear her request and order the sexual sterilization of Mrs. E's daughter, right? That would be a sort of consequentialist argument, but I've just delivered it off the top of my head. That's what we're looking for. I didn't write that. I didn't plan that so much. I spoke it in real time. One of the things we will certainly deduct for, if we believe there is collusion between the judges and counsel, like a planted question and I'm reading an answer, that's really academic dishonesty. Please do not do that. That essentially wrecks the whole point of the exercise, which is to train you to be able to speak in public from your natural voice to win an argument, which is an important skill, not because you're going to become a lawyer, but because you're going to be an agent in whatever institutions you're part of, public schools, recreational programs for youth, um, working as a youth probation officer, being a child life specialist, as any professional, you're going to be able to have to explain to your peers why a decision should be made. And to do that powerfully in your own voice, responsive to the context, is the skill we're trying to develop. So that's the spirit of moot court. It's much bigger than the law itself. It's a way to arm you for your life after King's. The justices have a different job. There are a lot of principles that are similar for the justices as well as for counsel, but their main role is to ask questions. So when we go through the process, there's an opening statement from the appellants, and then the second step is justices ask them questions. Um, what we're looking for is, can the justices ask questions that show an understanding of the facts of the case or the key issues? That means questions before the court. Can the justices respond to what the counsel has just said, or are they on autopilot? Are they able to actually look, rather than just, again, reading from a computer, look at their peer and say, Josephine, you just said X. Could you explain that further? Or I don't see how your side gets over this problem or this contradiction. So ask questions that are responsive to what has been said and adjust what you've prepared for what is happening. Another key thing is sometimes justices will come in and they'll have their prepared questions and they'll read them, and the answer from counsel won't be an answer to the question. It'll sort of sidestep the question or it'll redirect the question. And the justice will just say, okay, you are a Supreme Court judge. You don't just say, okay. What we want you to do is to be able to follow up and say, Mr. So and so, Ms. So and so, you haven't really answered my question, and rephrase the question. Are your questions specific to the legal issues, or are they just broad ethical, social, moral questions? Remember, this is a court of law that has to decide on specific questions of law. If you deviate from those specific questions of law, then you're not really engaging with the material of the course. Of course, justices should not collude with counsel. I also provide here summaries of what the announcer will do, what the timekeeper will do, what the public will do. And then I outline, I say some general words about how the moot will be evaluated. Here on the page, I outline how the process will go. And I even provide here a script. Let me just click on that. So this is a script that is the general script for our course. And it gives, certain things will be said in the first step. We'll have a call to order, and then opening statements and questions from the justices, and then a recess for counsel to get their rebuttal together, and then counsel will rebut, and then the justices will give a decision with reasons. So there's lots of material here to learn, and it's hard to absorb it all on the first day, but it's all provided here for you to review and to have questions about that you can bring in for the second week. If we go down here, after you go through moot court, you're also going to write a case brief, and some of you may have the case brief ready at the beginning of the day or earlier in the week. That's fine. You can You can submit at any time. But here are the instructions for the case brief. It's a 2 to 3 page double spaced paper. It's due by the end of the day of the moot. This gives you a chance, if you think about the timing, the week before the course, you read and prepare for your role in moot court. Then you play act the moot court uh, after you've received a lecture on the case. So reading, group work, preparing, lecture, moot court. That really puts you in a good position to make any adjustments you want to make to your case brief, um, and and to have that fully prepared. Uh, the case brief has 6 parts, um, and they're reviewed here. Every case brief will have facts and procedural history of the case, legal issues or questions before the court, the answers to those questions called the holdings, the judgment, which is what the court is ordered to be done. It's really easy to confuse answers to judge with orders, but they're distinct. It's one of the things you'll learn. Then these last 2 sections are really important. Why did the court review decide as they did? What was the key to their reasoning? And then why did the decision matter for childhood and youth in particular, or for other related, uh, could be for broader social questions. So that's the reading, lectures, mooting, briefing. That's the cycle we're going into 6 times, 6 chapters, 6 main cases throughout the course. So some final words here about participation, and I've mentioned these things earlier. There's, and I'm going to say things that are complicated here because this is an important issue. Some people will say, well, in the real world, you can't be late on anything or you can never miss work. That's not true. Um, it's better for your reputation if you are on time and are present. But what really hurts your reputation professionally is if you no show or you don't communicate. That's what people won't tolerate. So we're going to mimic those norms in this class. It's expected that you will try to schedule your life outside this course around the course. You're the one that enrolled. So it's expected that you'll be in lecture, you'll be in moot court, you'll be available for the tests. That's all the expectation. But it's also true that in a group of 60 people, there will be students almost every week that need an accommodation uh, to the general schedule, to the deadlines. So the key is to communicate. If you're unable to attend a moot, do a couple things prior to the moot. Ask me or one of the TAs to be excused from the moot and provide a reason. We're not going to be harsh in our judgment on reasons. We'll be very liberal in our approach. Anything that's a reasonable request, we'll try to do two things. Provide an excuse, so you'll have an excused absence and there will be no 0 assigned, which is key to doing well in the mooting part of the course. So you'll have an excuse, but what we'll also try to do, if you can communicate your needs early enough, we'll try to give you the less impactful roles when or give you the least impactful roles, like to be a time. We'll say you can be a public if you have a family wedding in March and you can't make uh, the RV Kaya moot that we're going to have in March. Okay, you're not going to be in London, so we'll assign you the role of public and we'll excuse you from the moot. That way, it's the least disruptive for the group. But even if things can't be rescheduled in terms of your role, if we give you an excused absence and then you notify your mooting team, hey, normally we have 5 students serving the role of counsel. This week there's only going to be 4 because Johnny's got a miss. If the other members of that council team know that you're gone, then they can prepare for that. So part of this is just being considerate. It's part of it is avoiding penalties for yourself, but part of it is being considerate of others. Of course, none of this is about um, life-altering experiences, a severe medical problem, death in the family, other injuries, other things. If you experience those things, of course you can come to me, but it's really about maybe there's a larger need for help or accommodation or a support from the college. Don't hesitate to ask for help at the dean's office with academic advising or under the office of the dean of students with student support services. And I can help you get to the right people. Those are 2 different things. If you just like have you know, I need to be rescheduled, we can usually handle that. But maybe there'll be something larger and we'll handle that differently. But the rules for both are the same. If you communicate your needs, we're going to try to help. And really, please do this beforehand if it's practical for you to do so. We also have a AI prohibition policy in our department, and here it is. Um, I don't know what to say about this. It's pretty clear in the departmental policy, but using the computer to write, to compose your briefs, um, or asking AIs to summarize academic literature, not only is there a question of reliability, will you be getting the right information? That's actually not my main concern, but there is that question. The much bigger question is your own development. If you rob yourself of the challenge of reading on your own and writing on your own, those skills and strengths won't develop. And one of the purposes of schools is to develop your basic reasoning and communication skills. Those are applicable in all walks of life, and they're why a university education is sought after and so valuable. Please don't rob yourself of those opportunities by relying on uh, artificial intelligence. Um, of course, we'll attempt to police this the best we can, but my main appeal is that you not rob yourself of your own education. So, what should you do this first week? Read the online syllabus carefully. Go to Brightspace and understand all the components of the course. If you have questions, write those down, bring them to class at the start of the second week, and I will address them. Get the book, read the prologue to the book, and start the first chapter, and then come to class next Thursday. Those are the 3 goals in the next week that you need to meet, and I'm really looking forward to being with you in person then and getting this course kicked off properly at that time. Take care.